सेव किया था ना?
मैं सिर्फ इसलिए गया था क्योंकि उसने मुझे कॉल किया, that's it. But listen तो.
Save it for someone else.
जिंदगी में सेव करना जरूरी है, मगर जब बात पैसों की हो, सिर्फ सेविंग से काम नहीं चलेगा। इक्विटी म्यूचुअल फंड्स में इन्वेस्ट कीजिए और अपने सेविंग्स को आगे बढ़ने का मौका दीजिए।
Mutual fund investments are subject to market risks. Read all scheme-related documents carefully.
The child's hand reached out of the mud, almost as if it had clawed its way out of its shallow grave in a desperate effort to catch the cricket ball that had soared over the boundary. Terrified, young Manoj Kumar jumped back over the high walls that closed off the service lane from the park, forgetting his mission to retrieve the ball. The children informed their elders about what Manoj had seen. The police were called in, but concluded there was evidence only of a boy with an overactive imagination. Ever since news of the Nithari killings case broke back in 2006, more than a year after that cricket match, India has learned every detail of the lurid story of Surinder Koli, rapist, necrophile, serial murderer and cannibal, helped by a tidal wave of tabloid television reportage. But the time's come for Indians to be asking themselves if the entire story isn't fiction, manufactured to help traffickers who may have murdered dozens of children and escape justice. Last week, a brilliantly reasoned Allahabad High Court judgment tore apart the confessional statement on which the entire Koli story was built. Evidence of incompetent police investigation and egregious prosecutorial misconduct has been mounting across the country. There is credible reason to believe that innocent men are on death for the Mumbai suburban train bombings of 2006, which claim more lives than 26/11 did. Earlier this year, the Rajasthan High Court acquitted men convicted of a terrorist bombing in Jaipur in 2008. There were disturbing signs evidence was planted in the Bhima Koregaon case. Something is clearly going badly wrong. Little imagination is needed to see just how rotten the Indian criminal justice system has become. Faced with political and public pressure, police have become adroit at finding suspects to lock up, even if they turn out years later to be the wrong ones. The Nithari case is just the latest in a long series of high-profile prosecutions that demand thorough reinvestigation to establish what actually happened and accountability for the individuals responsible for making a mess of the case. Koli might never have had the chance to clear his name. He was scheduled to have been hanged on the 12th of September 2014 and was granted a dramatic midnight reprieve by the Supreme Court Judge K.L. Datu. The Allahabad High Court later commuted his sentence in that one case to life. But Koli will remain in jail unless the Supreme Court reviews its 2011 decision upholding his conviction. That judgment asserted Koli would strangle his victims to death and, quote, after killing them, he had tried to have sex with the body and would then cut off their body parts and eat them. The story, as prosecutors had it, was that Koli would be driven to some kind of sexual frenzy when he saw his employer, Moninder Singh Pandey, engaged in orgies with sex workers. This would lead Koli, the story went, to murder and rape children. Except the Allahabad High Court judgment tells us now, there's little evidence to actually back up these claims. Following 2 uninterrupted months in police custody, during which the Class 7 dropout was offered no legal aid or even medical examination, Koli was finally produced before a magistrate to make a confession that could be admitted as evidence. The confession, the High Court records, contained extended testimony making clear that the police had compelled Koli to memorize the names of his purported victims and tutored him on the circumstances and times he was supposed to have killed them. The judge who recorded the confession did not explore Koli's video-recorded claims of torture. Koli even followed up with several letters mentioning that he had been beaten up and treated horribly in custody. For the confession to be believable, the High Court notes, one would have to accept Koli, quote, had no clear recollection of the nature and manner in which he disposed of the bodies, or whether he had sex with them, or whether he ate parts of them, but has a clear and categorical recollection of the time, sequence, and manner of entrapping his victims. That's just unbelievable. The illegalities in the confession are matched only by its inconsistency with other evidence, the High Court notes. The idea that Koli was driven by a sexual motive sits uncomfortably with the fact that only skulls, hands, and feet were found in the drain behind the home where he worked. The missing torsos were never explained by investigators. Forensic tests were not carried out to see if any DNA could be recovered from the area where Koli allegedly cooked and ate his victims' livers. Local residents did not even report the stench of decomposing bodies, suggesting the torsos were taken elsewhere. Indeed, the court notes, experts consulted by the National Commission for Women found that the bodies of the victims were, and this is important, cut with surgical precision. An observation that suggests they might have been kidnapped for organ trafficking. The repeated use of narco analysis involving the administration of the hypnotic drug sodium thiopental probably had something to do with the strange sadomasochistic fantasies that emerged in Koli's testimony. For decades, scholars have known that so-called narco analysis makes subjects highly susceptible to suggestion and can even lead to false memories being implanted. Efforts to rehabilitate narco-analysis after 9/11 failed in the United States, but the disreputable science began to flourish in India. Although the Supreme Court allows narco-analysis only with the consent of subjects and its results are not admissible in evidence, the Koli case shows how it can lead investigators into the thickets of fantasy. Elsewhere in the world, the science and judicial communities have been increasingly concerned over the impact of pseudoscience on criminal investigation. Even practices like fingerprint recognition, bite mark matching, and blood spatter analysis, a 2009 review by the United States National Academy of Sciences noted, have never been subjected to the gold standard of double-blind trials. Fabrication of evidence has, recent judgments show, become routine in cases. The Rajasthan terror acquittals were the outcome, in part, of the High Court detecting crude malpractices. The police produced a bill for a cycle that alleged terrorist Mohammad Saif was said to have purchased to plant the bomb. The frame number in the bill, though, didn't match the cycle used to plant the bomb, even though every other bill issued by the Anju Cycle Company bore grooves where it was torn from the bill book. Moreover, this single one was completely smooth. Strange. Amazingly, investigators never seized and studied user records or the central processing unit at the Naveen Cafe's computer from where the Indian Mujahideen had sent its claim of responsibility. The police did submit a site map of the premises, but that site map brilliantly did not show there was ever a computer there. The Mumbai train blasts of 2006, one charge sheet asserts, and I quote, were carried out by Indian Mujahideen operatives, including but not limited to Sadiq Sheikh, Bada Sajid, Atif Amin, and Abu Rashid. Those are completely different people to the ones the Mumbai police has secured a death penalty for. The fate of these cases at the apex of the criminal justice system points to the ill health of the entire ecosystem of the administration of law in India. If investigation and prosecution are this suspect in high-profile cases conducted under intense public pressure and media scrutiny, the fate of hundreds of thousands of other ordinary suspects should be a real reason for concern. Late one summer afternoon in 1854, Faujdar Muhammad Sheikh and 5 other police officers dragged a man called Gunnu Kunbi into a cowshed, held his face down in the filth, and sodomized him with an umbrella until he confessed, the scholar Anupama Rao records. Gunnu was led to the well where the body of his 5-year-old niece had been dropped and made to admit his guilt to the assembled villagers. 2 days later, on 13th August 1854, Gunnu died in a Nasik police cell, hemorrhaging into his intestines. Laziness, an imperial civil servant explained to the judge and philosopher James Fitzpatrick Stephen when they discussed why colonial police tortured. It's far pleasanter to sit comfortably in the shade, rubbing red pepper in a poor devil's eyes, than to go about in the sun hunting up evidence. The Nithari case shows India's police forces are still administering a regime of criminal injustice. The victims and our country deserve better. I'm Praveen Swami and I'm National Security Editor of ThePrint. Thank you for watching Security Code.